Hi, welcome to NYU Apulso's 15th Annual Korematsu Lecture. My name is Michelle Kim, and along with Minju Kim, we are the co-chairs for this event. The Korematsu Lecture was started in 2000 by a group of NYU law students who wished to create a lecture series in honor of Japanese internment challenger Fred Korematsu. This lecture provides a space in which to address Asian American perspectives on the law and to honor Asian Americans who have substantially contributed to the development of the law while challenging the status quo. Each year, we invite a distinguished member of the Asian American legal community to speak on issues current to the evolving legal landscape. This year, we are honored to have Judge Lorna Schofield as our Korematsu lecturer. She became the first Filipino-American to serve as an Article III federal judge when she was confirmed by a unanimous U.S. Senate vote as the United States District Judge for the Southern District of New York on December 13, 2012. Without further ado, I'm happy to introduce the Dean of the Law School, Dean Morrison, who will introduce our esteemed guest tonight.
Thanks, Michelle. Welcome, everyone, and good evening. It's terrific to be with you for the 15th Annual Korematsu Lecture. As you just heard, it's named after Fred Korematsu, who famously challenged the internment of Japanese Americans in World War II, leading to his prosecution for violating an exclusion order in a case that ultimately found its way to the Supreme Court. So those of us who teach and study constitutional law know the name, of course, as the last name of Fred Korematsu is the name also of the Korematsu case, which is truly one of the least happy moments in U.S. constitutional law over the course of the 20th century. So it's both worth celebrating Fred Korematsu, and it's a sobering reminder of the judicial system's engagement with themes of bias, in fact, themes that will be addressed by our honored speaker this evening, and we all really look forward to that. It's my job to introduce her, the Honorable Lorna Schofield, class of 1981 from NYU Law School, and now a judge sitting on the Southern District of New York. Judge Schofield was confirmed by a unanimous vote on December 13th, 2012. That by itself is a massive accomplishment. In an era where unanimity is utterly lacking, it's wonderful that she was confirmed in that way. She is the first person of Filipino-American ancestry to serve as an Article III federal judge in the history of the United States. Previously, she was a litigation partner at Debevoise and Plimpton, where her practice focused on complex commercial litigation. Prior to that, she served for 4 years as an assistant United States attorney in the Southern District of New York, working on a range of cases from domestic terrorism to tax fraud. And for 3 years before that, she was an associate at Cleary Gottlieb Steen and Hamilton. Throughout her legal career, Judge Schofield has been heavily involved with public organizations such as the American Bar Association, holding many leadership positions, including chair of the section of litigation. She's also written and spoken widely about trial tactics, women in the legal profession, and a host of other issues. We are deeply proud to count Judge Schofield as a graduate of this law school and very grateful that she is with us tonight. So without further ado, Judge Schofield.
So first of all, thank you, Apulso and NYU, for this wonderful invitation and opportunity to talk to you and to think about some important issues. Thank you, Dean Morrison, for the introduction and also making the time to be here and join us. Thank you also, I'll be done with the thank yous in a minute, but thank you also to my partner and my daughter who are here and support me in all things, and especially the team from my chambers who almost outnumber the rest of you, and who make all things possible in my work life, including their support on this wonderful speech. So I wanted to talk to you a little bit about being a new judge and what that's like and how I've encountered some of the issues that a judge does encounter. And first of all, you have to understand being a judge is sort of an odd experience because all of a sudden when you walk by, people say, "Hello, Your Honor." And your first name becomes judge, and your taller and more beautiful, and you weigh less. You no longer need cosmetic surgery, and all things are good in your life. The other good news is you wear a black robe to cover whatever you're wearing, so at least in the courthouse, no one mistakes you for the court reporter, the stenographer, somebody's wife, somebody's secretary, or anything else they might think you are. There are other surprises, too, and one of them is working with juries. I have great respect for juries. And when you think about what they do, that's a little bit odd, too. We take people and we basically force them to come in and leave their lives and give up their jobs and whatever other commitments they have and spend several days to several weeks with us. And we force them to listen and look at things that they may have no interest in, that they may find repugnant, that they may find even painful, and yet they participate in this as part of their civic duty. And then we lock them in a room with a group of strangers, and we make them make important decisions about somebody else's life and livelihood. And it's an extraordinary system, and extraordinary that it works, but of course it's a part of our history. But as a judge, I bring my unique worries to it. My daughter will tell you I bring my unique worries to everything, but my unique worries about being a judge are that as a judge, I actually have a lot of a large role to play in how a jury gets selected and who we end up with in our juries that sit in my courtroom. And so I feel that I have to think about it and have to think about what that means. So, as I said, the jury system seems a little odd when you think about it, but another aspect that is a little odd is we don't look for people who are experts in the law. We don't look for people who are experts in the facts. In fact, we might get rid of jurors or prospective jurors because they're experts in this fashion. And instead what we do is we look for people who we think and hope know absolutely nothing about the case at hand. And you might say, well, what are we looking for if we're not looking for expertise? And what we're looking for, of course, is impartiality. And the U.S. Constitution, of course, says that, at least for criminal cases, the defendant is entitled to a trial by an impartial jury. That's been extended to civil cases. So impartiality is what we're all looking for. But the problem is, when you think about impartiality, it's not so easy to figure what that really means. So when I think about it, everyone has a viewpoint, everyone has their experience, everyone has what they've done in their lives. And so how can it be that someone has no bias? In the Southern District of New York, you can see as much diversity as we might see anywhere in the world. And so, where are these screens? Okay, we have screens here and here. You can see just on this little map that there are all sorts of cultural communities in Manhattan. There are communities like Chinatown and Koreatown here in the city. You have a Vietnamese and Cambodian community in University Heights in the Bronx. And so there are all sorts of people. There are old people and young people. There are highly literate people and uneducated people. It's a very diverse place. Also, if you look at the geography, and who knew where all these counties were? How many native New Yorkers do we have here? Please raise your hands. Okay, not very many. But this is the Southern District of New York, and we think mostly of Manhattan and the Bronx as being the Southern District of New York, but you can see geographically they're very tiny areas at the bottom. And we also have counties like Westchester, which of course is a suburban place. And then we have counties that I think qualify as rural. We've got Rockland County, Putnam, Dutchess, Orange, and Sullivan counties. So just looking at the Southern District of New York, you can see that we have an urban environment, a suburban environment, and a rural environment, and the people who come from all those places. So it's nearly impossible to think that a newly naturalized citizen in Chinatown, and I'm told you will all know who this person on the left is, holds the same views as a hipster from the Lower East Side, and I think you can just vaguely see her tattoos there in the middle, or a farmer in Dutchess County, and you see him with his calf. So As many studies have shown, what we aim for to try to get impartiality in juries is diversity. And what studies have shown is that the more diverse a jury is, the more robust their deliberation, the more they consider different points of view, and the more deliberative they are about the evidence. So the goal, generally speaking, in getting an impartial jury is to get a diverse jury. So what I want to talk about now is the process of jury selection, at least in my courtroom, and how that fits with this whole idea of bias and impartiality. So to begin with, there are various requirements for jurors that serve in New York City. First, anywhere, you have to be a citizen before you can serve on a jury. You must be English speaking, and I'm told approximately 44% of Latinos and 40% of Asian Americans have limited English proficiency. Of course, we don't know if all of those people are citizens, so we don't know how much this limits the juries, but we know that already to some extent jurors are limited by these requirements. And in the Southern District of New York, the juror names are come exclusively from the voting rolls. It's different in different districts. They can set their own requirements. So that also means that a certain segment of the population will appear as potential jurors. So when I get to the courtroom, I make a speech something like this, and I don't think I'll read it to you because I hate it when people read PowerPoints, but you can sort of see what it says. And the language that I wonder about, and that I was wondering about as I was giving this talk, is telling the jurors that we're trying to select people who are free from any preconceived notions or any sympathies or prejudices that might prevent them from returning a fair and just verdict based solely on the evidence. What are those preconceived notions and sympathies or prejudices that stand in the way of a fair verdict? And then what we're trying to find out, we tell them, is we're trying to find out if there's anything in your background that might improperly affect you as a juror. Well, what are those things that will improperly affect someone as a juror? So what we do is we have a process called voir dire. I know you're all law students, so maybe you all know this, but the voir dire is the questioning of the jurors. And the first thing that happens is there's a summary of the case. I tell them a little bit what it's about so they understand why I'm asking these questions. And then there are questions basically to eliminate jurors for cause based on their inability to serve or what is perceived as bias. And then once I have a panel of jurors who are free from cause and the right number, which means the number of jurors plus the number of alternates plus the number of peremptory challenges. Then I ask biographical questions, the lawyers make their peremptory challenges, and then we have a jury. Sounds simple, usually takes about half a day. But as I began to think about this, I began to think more about bias and whether our voir dire really does a good job at getting at the issue of bias. So the first thing we do, or that I do, is I ask questions that are aimed at getting at people who are unable to serve. In other words, people who have trouble hearing, people who might not speak English, people who can't sit for long periods of time, anything that would actually disable them from serving. But then I get to questions that are designed for the issue of bias, and that is what I really want to focus on here. So most of the questions that we ask during voir dire are aimed at getting at a particular kind of bias. So I ask whether the jurors, this part is obvious, I ask whether they know the parties or the lawyers or the witnesses who will be involved in the case, and I ask whether they have experiences with the legal system as lawyers, as witnesses, as participants, as parties, that left them in a position or with a state of mind that they can't participate. But most relevant for our purposes right here is that I ask them questions about matters that touch on the lawsuit. Questions that might uncover whether they're like the judge here vis-a-vis a defendant here in the slide. So for example, in a personal injury lawsuit by someone who's been hurt when their back went out when a train derailed, and I really had a case like that in federal court, don't think it doesn't happen. I'll ask if anyone's been injured while they were on a train, or if anyone has suffered a back injury. And in an employment discrimination case, for example, I'll ask if anyone feels that they have been treated unfairly in the workplace on account of their race or gender or sexual preference or age or some other characteristic. And all of those questions are designed to see whether these people are too close, whether there's a proximity bias. And so if the answer is yes, I'll take them back in the robing room with the lawyers and the parties and speak to them as privately as you can with those people and try to get more information about what their experience was and how close it is, and whether or not they identify with the parties or with something that happened in the lawsuit. And finally, I'll ask whether that experience would prevent them from being fair and impartial in this case. And generally, if somebody says that they can't be fair, they're struck. And if someone says they can be fair, we take them at their word and they are not struck for cause. And that's it. So that's it at that phase anyway. So you can see that there is questioning to try to test for this proximity bias. And now I want to tell you a little bit about challenging a juror for cause. Generally what happens is then that juror walks out of the robing room, I stay with the lawyers and parties, and I'll say, I'd like to strike this person for cause. And usually it's so obvious I will do it, and the parties don't even have to move. And it's the judge who makes the strikes for cause. So the first kind of person who is struck is, I call this the gleeful juror. The gleeful juror is someone who clearly wants to be excused, who has heard that serving on a jury is like standing in line at the Department of Motor Vehicles, and somebody actually told me that once. But just so you feel better about it, he said, I thought it would be like that, but actually it was a wonderful experience. But I've actually had a juror, prospective juror, who said, you know, I know this is a case where the police will testify, and you asked if I could be fair and impartial and give the police testimony just as much weight as anybody else's testimony. Well, you know, my best friends are all cops. I know they're telling the truth, and I'm going to give their testimony a lot more weight than everybody else's testimony. And then I get a big, broad grin from the person because they know, we all know, that I have to excuse them. And who knows if they're telling the truth, but they clearly don't want to serve, and with that kind of record, they clearly will not serve. So the next kind of person who gets struck for cause, I call the reluctant or apologetic juror. And they often say, oh, I will try to be fair, but I'm not sure I can. I had an experience that was sort of like this, and I really hope that I can, and I really, really will try. And then I say, sorry, trying is not good enough. Will you be fair and impartial? And that is often where the rubber meets the road. And if they don't say unequivocally yes, then I will usually strike them for cause. And then, and this is actually the hardest, is the pained juror, because I tell the jurors that they can speak to me privately if there's someone they'd rather not discuss in front of everyone else. But what they don't realize is that privately means with all of the lawyers and the parties. So we go off into the robing room, and often there's a crowd of, you know, maybe 10 of us. And so these are people who've had a painful or traumatic experience in their life that excuses them from the jury. And in a recent case, it was a child pornography case, a criminal case. One of the prospective jurors came in and explained that he had been sexually abused as a child. It was clear he was having trouble telling us all of this. He said he thought he had left that memory behind him, but as he was listening to me describe the case, his hands became sweaty and his heart started beating quickly, and he realized he just couldn't do it. And of course I excused him. So there are many different reasons and kinds of challenges for cause, but basically they're jurors who say that they can't be impartial. So I talked about proximity bias, and that's what we all think of when we think of bias and whether someone is too close to the case to be fair. But just as a closely related personal experience can create bias, so can the lack of knowledge or experience. Being too far from a case may mean that the juror lacks any knowledge or perspective to judge what the case is about, what the motives of the witnesses may be, and what the credibility of witnesses may be. And this is my slide for distance bias. So it seems pretty clear that this fellow is going to have a lot of trouble relating to what he hears on the witness stand. And so the idea is that there is a kind of bias from being too far from the facts in the same way that there is from being too close to the facts. And I was, as I was preparing this, I was sort of struck by how profound an idea this is, and this was not my idea. I've actually encountered only one article that addressed it, and it's by Martha Minow, who's the dean at the Harvard Law School, and she wrote it some years ago in 1992, and it talks about bias and impartiality of judges and jurors, and it was a very unique way of looking at bias. She says jurors need sufficient knowledge of the life experiences of those before them to make sense of testimony and motivations. And the reason this idea of distance and being too far from the facts, the reason this struck me is because when there seems to be some imbalance on the jury, it's usually about this. It's usually because there is too much distance on the part of the jurors from what's happening. So let me give you an example. Take a personal injury case involving a woman who was trampled on an escalator in Penn Station on New Year's Eve. The train platform got too full. People are coming down the escalator. The platform fills up. People on the elevator start saying, go back, go back. So some people are turning around trying to go up backwards on the elevator. She's from out of town. She doesn't know what to do. She eventually gets trampled, and she's seriously injured in this incident on New Year's Eve. So consider some hypotheticals about picking a jury. So here's one prospective juror. Let's say you have someone who works in Manhattan, lives in the burbs, commutes by train every day, let's say into Penn Station, and is there during rush hour, 5 days a week. And that person is close, but I would think not too close to the facts. No one is going to try to strike that juror for cause or say that that juror can't be fair. And let's just add one more fact. Let's say that juror was in Penn Station on New Year's Eve, on the night the woman got trampled. Is he likely to stay on the jury? Probably not, because you might say he was too close. He might become, in effect, a witness or an expert and sort of take over the jury deliberations. So now contrast somebody else. Remember the picture of the farmer with the calf? So let's take that guy. Let's assume that he is on our jury panel, and let's assume he's never been on a train in rush hour. He's never been in a crowd that required crowd control. He's never been in Manhattan on New Year's Eve, which is something not to be believed unless you've been there, right? I assume some of you have done that. And so, and just so you understand, that was basically me when I came here to NYU to go to law school. I had not been in any of those situations. So the first issue is it's unlikely you'll discover those facts in voir dire. You're not going to learn about all those things because those aren't the questions that get asked. But you might ask yourself, how is this person who is unfamiliar with crowds and busy train stations in a position to evaluate the reasonableness of the defendant train station's actions in preventing this problem? And how good a position is that person in to evaluate the contributory negligence of the plaintiff in acting the way she did on the stairs of this escalator? And you might say that that person is not in a very good position at all, and that's because that person is too distant from the facts. But those are the kinds of questions that don't really get asked in voir dire. And so then add another layer to it. Let's imagine that the plaintiff is just like the prospective juror, someone who's never been in a dangerous crowd on an escalator on New Year's Eve. Is that a useful perspective in the juror, or is that a biased perspective? you can imagine that the defense, regardless, is going to find a way to get rid of that juror, either for cause or on a peremptory challenge. So let's take an even more challenging case. Let's take a case about a department store that's being sued for doing surveillance on people who are of a different race than other people. And let's say that during jury selection, there are people like the plaintiff, the same race as the plaintiff, who've been subject to the same type of surveillance. And so we'd ask during voir dire, has anyone ever been subjected to the same kind of surveillance that the plaintiff complains of? And you have these people of the same race raising their hands. And again, if you're the defendant, it's very likely that you will try to get these people dismissed for cause, or that you'll at least want the judge to ask questions like, can you be fair and impartial if you've been subjected to the same treatment that the plaintiff has been subjected to? How did you feel about that treatment? Did it make you angry? Did it make you upset? Are you sure you can be fair? And there's likely to be a real question about the impartiality of the person who has suffered that experience. But then let's take a look at the flip side of the coin. Let's look at a different kind of juror, the one who comes from the majority viewpoint, the person who has never had that experience, who is of a race so that they never get surveilled in department stores. So that person is likely to think that this experience is rare, or that it's improbable, or perhaps they're more likely to credit people in the department store who say that this person was acting suspiciously. Is that person impartial? You might question that. But because of the way the questions get asked, it's very likely that in the case that I just gave you, the people of the same race as the plaintiff who have suffered the same kind of surveillance will be struck from the jury, and you will be left only with people for whom this is entirely foreign. And that struck me as something that really needed to be thought about, an issue that I, as a judge, needed to think about. But before I go into how one solves these problems, because I confess right now I don't have quick and easy answers, I'll go to the next stage of the voir dire. So after we do the questions to eliminate jurors for cause and ask these questions about bias, we end up with the right number of jurors so that basically all we have to do is strike the ones who are subject to peremptory challenges. And so I ask the biographical questions. I ask where they live, basically if they're the hipster on the Lower East Side or if they're the farmer with a cow. And I ask what they and members of their household do for a living. And I will confess that I think it was in my first jury trial, I asked whether they lived with their spouse and outed somebody unintentionally as I was doing the voir dire, so now I just ask, who lives in your household? I ask about hobbies, what they read regularly, how they get their news, what organizations they belong to. And I actually love this part of jury selection because it goes very quickly. It's like speed dating, you know? You get just a little bit about each person and you feel like you know them just a little bit. So after the speed dating come the peremptory challenges from the lawyers. And the lawyers are entitled to strike people for any reason at all, as long as it's not based on race or gender. So from the lawyer's point of view, it's a tool for eliminating jurors who will be less sympathetic to their client or who may be undesirable for some other reason. And as you can imagine, these peremptory challenges are often based on stereotypes and generalizations. So lawyers defend them, saying they have so little information about prospective jurors, they don't have any choice but to rely on generalizations and stereotypes. And so they judge people based on the limited information they have. They look at them, they look at their race, their gender, their age, their attitude in the courtroom, and they have a small amount of information. So if you know that someone is the president of their co-op board, oh, a leader, is that somebody we want on the jury? Depends on what their other views are likely to be. So you should also know that some people pay jury consultants a lot of money to try to figure these things out for them. Peremptory challenges have been criticized on the ground that they encourage bias and they encourage stereotypes. And justices Breyer and Marshall and several scholars as well have advocated just getting rid of peremptory challenges. But leaving all that aside, it's not always obvious why people strike the jurors that they do. And so going back to this child pornography case I recently had, I looked at what the strikes were to see if I could find any patterns. And on the defense side, I saw them striking parents of small children. Well, that's not really a surprise in a child pornography case because of that proximity bias. You might be afraid that people would identify too much with the children that they were seeing. They were also striking, on the defense side, churchgoers, perhaps thinking that they were more conservative than other people, and non-city dwellers, all those people from those big counties north of the Bronx and Manhattan, again, perhaps thinking that they were not as sophisticated or perhaps more conservative. On the other hand, the government, there were 2 gay men in this jury panel. Both of them were struck by the government, perhaps generalizing and thinking that they might be less prudish than other people, again, relying on stereotypes. And what you may not know, and I did not know, is that a child pornography case is almost entirely about tech issues and computers and peer-to-peer file sharing and things like that. I learned more about that than one could ever want to know. And that was the issue of proximity. The government didn't want tech experts on the jury panel who could second guess the experts who they were putting on the stand. And so the peremptory challenges are an opportunity for the lawyers to make these kind of generalizations and strike people based on them. But now I have to talk about another issue, and that is the final voir dire question, which sort of relates to the first issue I talked about. So I say to them, whenever all of this is done, let me ask you one final time, is there anything, whether I've asked you specifically about it or not, that would affect your ability to render a fair and impartial verdict in this case? And there you get into 2 kinds of bias that people talk and write about more these days. One is explicit bias. And if people haven't already tried to get off of the jury because of their bias, it's unlikely that they will admit to you that they are racist or that they feel a prejudice for or against somebody who's involved in the case. But there's also something called implicit bias, and there's a lot of writing that's been done about implicit bias in the last, 5 years or so. But implicit bias is a kind of bias, or it's attitudes, feelings, and beliefs that you may not even be aware that you have and that you probably don't endorse. And so, for example, you may have read recently, in fact, this is the kind of crowd who might have, there was a study of faculty members at universities who received applications, and they were much more likely to respond to applications from American, in quotes, sounding names as opposed to other kinds of names. Now, do we conclude from this that all of those university professors were blatantly racist and were looking for those white names? No, probably not. The answer is that there was some kind of implicit bias going on that they might not even have been aware of. Or, just to bring it more close to home, you don't have to confess to me, have you ever made an assumption about someone based on a stereotype? Somebody's talking about their doctor and you say, oh, what did he say? And the person says, she. And you think, oh yeah, she. Well, of course. Or worse, you get in an elevator and the person with you is a person of another race and you think, oh, that person must work here. And you don't think they're visiting here until you talk to them for a moment and you find to your embarrassment that you have just been guilty of implicit bias. I think we've all been there, and we don't like it when it happens to us because it reveals something that we don't like about ourselves. But the fact is, it's there, and it affects things we do, and you can't get jurors to confess to it because they don't even know it's there. So there are difficult questions about voir dire aimed at sort of self-confession about bias when what you're trying to uncover is implicit bias. So what I've identified are a couple of what I think are hard problems. One is this too much distance problem, and the other is implicit bias. And I think the voir dire that we currently have doesn't really do very much to address these problems. And so I thought, what can I as a judge do? The nice thing about voir dire and being a judge is you can pretty much do whatever you want. You can ask whatever you want. And so I thought that as far as the distance question, I could actually ask questions like, have you ever been in a crowded train station? Have you ever been in a crowd that required crowd control? The kinds of questions that might not be asked if you were only looking for proximity bias. And then perhaps I could ask questions that might tee up challenges for cause for these people. I could also, in the biographical questioning, I could elicit more information about people's experience that could elicit more peremptory challenges based on distance. And I could try, in some abstract way, to get a jury that is more diverse, because that, of course, is the goal, by having people both who are close and distant. Because if you have both those perspectives on the jury, in theory, you'll have a more impartial jury. Now, as to the issue of implicit bias, what I've read is that it's malleable. Once people realize they have this bias, they're much more likely to be able to be conscious of it and try to counteract it. And I have also seen studies that say if you give an instruction to the jury about implicit bias and the danger of implicit bias before they hear the evidence, it is likely to be more effective, at least, than giving the charge after they've heard the evidence. And finally, you could tailor these charges to the facts of the case. So this has been a wonderful opportunity for me to begin to think about what I can do as a judge about these hard areas of bias. Oops, not yet. Okay, not the wedding picture. In any event, that's juries and bias. And I'll just say a little bit about judges and bias, because of course, we all like to think that we're not biased. But as I just explained, of course we all are, at least a little bit. We all come from our own perspective. We all have our own experience and point of view. So we tell the jury that the facts are the province of the jury and the law is the province of the judge. And I'm told that the reason we wear black robes, and in England that they also wear white wigs, is so everyone will look alike. And in theory, then, it will send the message that we are all the same. All the judges are the same and impartial and will apply the law in the same way. And Justice Roberts likes to say that judges are like umpires. We're just calling the balls and strikes. And that's actually true a lot of the time. You know, people say, how can you rely on your law clerks, many of whom are here, to help you make all these hard decisions? And the reason is that, another saying is, we find the law, we don't make the law. So what you learn in law school about finding the law is actually what judges do 95, 98% of the time. But the challenge is that other 2% of the time, when a judge is really required to use some discretion. And of course, there are guidelines and principles, there are courts of appeal, who I suppose are only too happy to reverse us, but there are times like sentencing a defendant, where a judge has tremendous power and tremendous discretion, and by the way, that is the most unpleasant part of this otherwise wonderful job. Another aspect where a judge exercises great discretion, you might not even appreciate this, is in the management of a case. How fast it gets to go, how many depositions someone's permitted to take, how much document discovery happens. All those things can dramatically impact the outcome of a case, but it's all sort of under the rubric of case management where a judge has tremendous discretion. So are judges biased? Well, I think we've seen there are issues of bias, too much distance, implicit bias, and people who are human. That is just the nature of being human. And there's one judge, if you want to see if you're biased, and I bet you are, there's a test at the Harvard website, and it's called the Implicit Association Test, where you can go to test yourself for racial bias. And there was one judge who wrote an article and said he was very smug and proud that he knew he harbored no bias and took this test, and sure enough, it showed that he did, and he was quite horrified by it. And so I think, again, knowing that there's bias there is something that is the first step in trying to deal with it in these 2 or 3% of cases where judges have so much discretion. But bias is a funny word because it's so value-laden. And there's another way of looking at it, which is just perspective. We all have the perspective of who we are and where we've been, what our experiences are, where we grew up, what's happened to us. And some things are foreign, some things are not, some things we know about, some things we don't. And this was brought home to me recently when I read a book called On the Run. Has anybody read On the Run? No, you all are studying too much. One person? Okay, good. So it was written by a white woman, a sociologist, who lived with and wrote about the experience of young black men in a neighborhood in Philadelphia. And she explained how onerous it was for them to be supervised by the probation department when they got out of prison. Because normally there are a lot of conditions imposed. You can't be out after curfew. You can't be caught smoking pot. You have to report to your probation officer. And in the normal course, it's easy for these young men to violate these conditions. And so as a result, they have arrest warrants out for them. And that means, this sort of struck me and horrified me, that they avoid places where the police hang out expecting to find them, like hospitals when they're injured. They don't go to hospitals. They don't go to the hospital to see their girlfriends when their girlfriends are having babies because they don't want to be caught by the police. They don't go to the funerals of friends for the same reason. And they don't even go to places to work. And so as a result, these young men are literally on the run. So as a judge, I impose post-release supervision conditions all the time, and I think nothing of it. I think, oh, well, I'm helping these people. Somebody's going to supervise them and help them get their life together. And I assumed that it was not a big deal, or at least a good thing. But I think that comes from being uninformed. I had no idea. How would I know? That's not my background. And so what I realized is having more information coming from another place, knowing other things, and trying to educate myself can help counteract some of this just limited perspective that all of us have just from living in our own skin. So you probably are now wondering, well, what's she like? What is her story? And what is her perspective? So I'll share a little bit of that. I grew up in an unlikely place, I think, in New Haven, Indiana. I was the only child of a Filipino war bride. Now you get the wedding picture. This is my mom. She married an American serviceman and came to this country and was thrilled and delighted to become an American citizen because that was her goal. The Americans saved the Philippines in the war, at least in her view. And so that was great until I was 3 and my father left. And I don't fault him. There were a lot of reasons that marriage wasn't going to work out. But I think of how different my life would have been if my mother had gone back to the Philippines and taken me with her. I'd be giving this speech in the Philippines, right? I wouldn't be here in New York. And but she couldn't go home to the Philippines. She always called it home. And the reason is that divorce was shameful there. In fact, in those days, not until very recently, has divorce even been legal or recognized in the Philippines. And so she stayed here because she really didn't have an option to go anywhere else. And she was a pharmacist, and perhaps because she was divorced, she stressed achievement and independence and self-sufficiency. She said, don't rely on anyone to take care of you. You need to be able to take care of yourself. And she was determined to raise me as a real American. And so she made rice for herself and potatoes for me. She spoke Tagalog with her friends, but she spoke English only with me. And that is how I grew up, in a very white, blue-collar community in the Midwest. How many of you are from the Midwest? 1? Come on. Okay, so 1. This was a very small, white, religious town, and there wasn't really very much ethnic awareness. Now, it was also the times we were living in. There wasn't ethnic awareness at all. So I was the only Asian American in my class. This is I found my junior year of high school yearbook, and you get an idea of what all these folks looked like. And they don't look a whole lot like me, except Tom is not in this picture. There was one African-American boy in my entire class. And I I didn't even realize it till I looked back at the yearbook. There were a couple of Hispanics too, but I didn't notice it. I didn't realize it because that's just not how people thought about these things. And there was no obvious prejudice in that time and place against minorities, but just a refusal to acknowledge otherness. So it was like if you're a woman having your slip showing or your bra strap showing, everybody was very polite and would kind of avert their eyes and just pretend it wasn't so, and people were nice. But clearly there was something that had to be overlooked. And I saw and this other fellow here, this is one of the people who I figured out was Hispanic. When I looked at my yearbook, I said, my gosh, there were Hispanic people in my class. I didn't even know that. So I saw Tom, who was the black person in my class, and at a high school reunion, and what I was really dying to say, but I thought it would be impolite, I wanted to say, Tom, when did you discover you were black? But like I said, I thought that would be rude. But what I really meant was, when did you become aware that you were culturally and ethnically different from all these people we grew up with? So I wasn't, you can guess this, I wasn't one of the popular girls. I wasn't a cheerleader. You knew that, right? So to do that at my school, you needed blonde hair, and you needed a particular kind of figure that I never had, and other qualities that I also never had. But never mind. But apart from that, I had a certain amount of respect because I was exotic looking, and that had some value to it. And I was the cornerstone of our speech and debate team, and so that had some value. And I was a little bit of a celebrity because I did community theater, and I acted in a television commercial for auto car parts wearing a red miniskirt and white go-go boots. And you can imagine this made me an instant celebrity in my high school. I wish I had a picture of that to show you, but I don't. So looking back, I now realize that as an Asian American, I was exoticized. And by that, I mean looked at with a certain distance because I was different. And so in the community theater, I'll tell you the roles I had. Here were three big ones. I was Tintinnabula, the Asian courtesan, in Funny Thing Happened on the Way to the Forum, and I had these little, hand symbols that I got to use. I was Patsy, the errant teenager who gets pregnant in Reimers of Eldritch. And I was the girl who boils her cat as a science project in The Effect of Gamma Rays in Man and Moon Marigolds. And I knew, because I'm a realist, that I could never be cast as part of the onstage family or the girl next door because I just didn't look the part. So you have to understand this is long before the word diversity had made it into our daily vocabulary. But despite that, I knew that my place was secure as one of the three Marys. I have to explain to you the three Marys. Every Christmas, there was a Christmas pageant, and there were three Marys, a black Mary, a white Mary, and an Asian Mary. But I was always the Asian Mary because there wasn't anybody else to be the Asian Mary, and I actually found this picture. So that is me as the Asian Mary. So although I didn't feel prejudice because I was Asian, or any obvious discrimination, I did learn that being a woman could be a really serious problem. The women's movement was in full flower in my circle of friends. We read magazines, Ms. Magazine. We didn't wear bras. We refused to shave our legs. We paid for our own way on dates. And this was all fairly radical coming when it did. And we also understood what was very plain to see, which is that women didn't make as much money as men and they didn't have the same opportunities as men. We created a club for feminists, and I became the governor of Girl State in Indiana, running on a platform of empowerment for women. Then I left, and I went to Indiana University, and this showed me a bigger but demographically similar world like the one you just saw. There were no women's studies programs yet, no Asian studies programs. I majored in English and German, and while I was there, my mother died, and so my single, tenuous relationship with the Philippines was gone. And I was 20 years old. I came back to New Haven. I picked out the things that I wanted from our house. There was a carved wooden caribou from the Philippines, which I brought and still have. And I was sad and actually cried because one of my friends cleaned out the refrigerator and all of the wonderful frozen Filipino food that my mother had put away in the freezer had been thrown out. So that was sort of it as far as my Philippine experience for a long time. After that, I went to Rhode Island for graduate school. I moved to New York for law school. And on my first subway ride, I remember being startled by how different everyone looked from the people where I had grown up. And then when I went back to New Haven, I was startled again because I suddenly realized I didn't look like they did, something that had escaped me for many of the years when I was living there. I remember when I got to NYU being a research assistant for Professor Andy Lowenfeld, and I mention Andy because I just learned today that Andy died last summer, and I had been his research assistant, and we had been friends over the years, and I was actually hoping to see him tonight. But Andy was Jewish, and his wife Elena was this wonderful, glamorous Cuban woman, and he had me his Filipino research assistant, and this was back in the day, and I am so grateful to him, and I mention him because he was open and gave me, as a woman and a woman of color, that wonderful opportunity that built a foundation for the rest of my career. I was astonished, though, at all of the little fine distinctions that white people make among themselves. The German people and the Jewish people and the Irish people. This was completely foreign to me. And I will tell you, I'm still learning what my own ethnic and cultural identity is. It didn't really happen to me until I was about to become the first Filipino-American Article III judge. And suddenly, people were saying, well, you know, what have you done for us? You want us to sponsor you. We're the Filipino community, but we don't know you. Who are you? And so given this title and being seen in this position, I am now a part of this community that I really want to know more about, but that in some ways is very unknown to me. So this is me at the Filipino Independence Day Parade in 2014 with Senator Schumer, who recommended me to President Obama. And I love these dresses. Wow, Filipino dresses, they are the best. So what does all this mean? I'll wrap it up now. I know it's been a while. What does it mean for me as a judge? I have my own viewpoints. I have my own perspectives. I, like all judges, try to overcome those things. And I believe that the principal benefit of having a diverse bench is the message it sends to people that our system of justice is open and accessible to everyone. And so another benefit is for those of you who came from the law school today, and it shows you that if it could happen to me and Judge Denny Chin and to Judge Doris Ling Cohan and lots of other people, it can happen to you. So thank you very much for listening. It's been a pleasure to be here, and I thank you for the opportunity to think about these interesting and serious topics. Is there anybody Filipino here? I'll ask that question. I'm Waddler. Okay, my daughter. Anyone else? Okay, hello. Where did you grow up?
California.
San Diego?
Northern California, San Francisco.
Good. Are there a lot of Filipinos there?
Not a lot. I didn't have much connection to the community.
You should come to the Filipino Independence Day Parade. Sure. Yes.
I have a question. So if you have the gut feeling that one side in a trial is using a peremptory strikes in a way that is biased with respect to race or gender, what can you do?
Well, there's something called the, can you hear me? I don't, okay. There's something called the Batson Challenge. United States versus Batson was a Supreme Court case. And it's the case that tries to ensure that people don't exercise their peremptory challenges based on race or gender. The problem, though, first of all, you wait for one of the parties to make a Batson challenge, and then, let's say it's a criminal case, and the government is striking people of a particular race. So you say to the government, can you articulate non-race-based reasons for your challenges? And all they have to do is articulate a colorable reason. It doesn't even have to be probable. So anything, you know, oh, they're from upstate, I don't like that. Oh, they read the New York Times instead of the Post, whatever. And then the burden shifts to the defense, who has the burden of persuasion, to show that that reason is pretextual. And I have read studies that say that it's very hard to succeed on a Batson challenge. I've only had one made in front of me, and I frankly don't think that's what was going on. So that is what is supposed to happen, but it's a difficult situation. And I'll also say, in fairness to the lawyers who appear in front of me, they know they're not supposed to do that, and so they don't. And so even if you see people, in a civil case, for example, both sides will get 3 peremptory challenges. You might see 2, let's say they don't want women, but they'll strike 2 women and 1 man. So it's because they know they're not supposed to strike based on any of those categories. Other questions? Yes.
Hi, Jessica Field. Thank you so much for the speech. This is wonderful. My question is about combating bias in districts apart from the Southern District of New York. It seems that the Southern District of New York is probably the most culturally diverse place, certainly in the country, if not the world. So how do you go about finding such diverse jurors in places like where you grew up, for example?
You know, it's an interesting question because in some ways it might be easier. What you really want, there's actually a statute that's been enacted that says that, what you want is a fair cross-section of the community. But if your community is sort of all the same, it's not so hard to get a fair cross-section of the community. And then you don't have this problem of someone who's very distant from the facts and someone who's very close to the facts, and the kind of tensions you get in the surveillance case that I told you about. If you live in a community that is entirely white and everyone is the same, that you don't have some of those tensions. Yes?
Just you mentioned that people like Denny Chen and yourself have shown us that it is possible to break through the bamboo ceiling to the extent that it still exists. What are some of the qualities that either speaking for yourself or in general you feel are valuable in helping us reach any obstructions that are still in the way?
I think the answer is a little bit boring, but let me ask it in a sideways way. How many of you here are second generation? And by that I mean, how many of you have one parent who was born somewhere else and immigrated here? Okay, I just happened to be looking because someone asked me to talk about second generation people. And it seems second generation people are distinctive because they do the things that we all need to do to succeed, which is work incredibly hard, even when it doesn't feel good, and to persevere, even when we are discouraged. I mean, just all the kind of, you know, not so exciting, boring things you hear, but you can look at your classmates and see who's successful. There are people who don't do that, and they don't do very well, and people who do often do. Now, that doesn't mean that there aren't more obstacles, because clearly there still are prejudices in the workplace and society about Asians as well as about all sorts of other people. And another thing to do is to be conscious of what the stereotype is. So actually, to prepare for this speech, I Googled stereotypes about Asians, just to see, right? And it's really hard for women because you have the Madame Butterfly and the China doll and the Dragon Lady and the Tiger Mom. Those are all, I mean, that's all in the mix. That's really hard. But a consistent theme is that the perception that Asians are meek and not assertive, and very good at technical things, but not very creative or brilliant. So if you know that those are the perceptions, you should be doing things all the time to fight them. So if you're in a meeting as a young professional, open your mouth and speak. Find something to say. Be conscious of the fact that you haven't spoken yet. I used to think, oh, I haven't said anything. I don't have anything to say. It's all right. But then I learned pretty quickly, you have to find something to say so people will notice you, so people will know that you're there and that you're not quiet and lacking in leadership and not assertive. Yes?
Your Honor, thank you for your wonderful lecture and sharing your personal biography. My question to you is with respect to bias particularly in the context of outside of suspect classifications, equal protection, gender, race, ethnicity, so on and so forth. At what point does such judicial bias rise to the level of an unconstitutional violation? And in those situations, what remedy might the aggrieved party have? Obviously, equitable relief comes to mind, but if you're the petitioner is suffering the bias, what thoughts do you have as an Article III judge as to remedies in a particular situation versus broad policy academic considerations on this topic? Thank you.
I'm happy to answer that. And the question is, what does one, perhaps a litigant, do when faced with bias in a judge? And what you can do is try to make be sure you're on the record every time that this bias occurs. And then you can make a motion for the judge to recuse him or herself. And you can keep pursuing that. And eventually, I think if the judge refuses to do it, if you ever get to an appellate court because you have a final decision, that's one of the things that you can challenge. Of course, that's difficult because most cases don't get to the appellate court for various reasons. Most cases just resolve and settle. But challenging the judge in that way is one possibility. Another is you can try and mandamus the judge for some obvious ruling that seemed obviously biased and wrong. But that's a very, very high standard to meet. Anything else? I'm standing between you and the food. Okay, I'll be here, so if anyone would like to talk one-on-one, I'm happy to do that.
On behalf of NYU Law and Appalsa community, I'd like to express great gratitude to Judge Schofield about your inspirational and wonderful lecture. We'll now have reception, so please enjoy the foods and refreshments that are prepared. And you can ask questions to Judge Schofield while staying here. Thank you for everyone for attending the event. Thank you.